Right, good afternoon then, everybody. We'll make a start. It's a couple of minutes after 2 o'clock. I'm just keeping an eye to see if participants are still joining, but I think we'll make a start in just a moment. This is going to be broadcast through the webinar function. So if you have any issues or questions, then by all means, if you want to pop them in the chat, I'll try and take breaks at various points to just check the chat as we move between the different subjects. And then I can try and deal with any questions as they come up and we go along. So by all means, use the chat function, as I can see some of you are already, just to share points or comments or to ask anything, and I'll deal with it if I can as we go there. So right, I'm just going to give people a couple of minutes because we still have people joining, and then we'll get started. Just to reassure people, I can see there's references in the chat to concern about whether or not you're on mute. Because of you're on the webinar function, you are all automatically muted. So don't worry about that as long as you can hear. And if not, then let us know in the chat and we'll try to help. You've been sent, I think, already a copy of the PowerPoint slides. The webinar's already is also being recorded, and you'll be sent the link to that after today's talk. So both there's some narrative notes that will come out to you as well as the PowerPoint slides. So if you don't have them already, please don't worry. They will be sent to you along with a copy of the recording afterwards. Right. All right then, well, it's 4 minutes past, so if we perhaps make a start. We're going to look this afternoon at transitions from children's social care to adult social care, which is always a difficult age group to work with. And it's an area that raises lots of different challenges and different situations for both lawyers and social care professionals, health professionals, and everybody involved in the care of teenagers. This talk's going to look at a variety of the different aspects. It's fair to say a lot of these individual aspects could quite easily fill a seminar on their own. So this is very much to give you an overview of the issues that arise when we're dealing with issues around older teenagers before the family court or before the court of protection or before the inherent jurisdiction. And we'll look this afternoon at some of the principles of law around transitions. We'll look at deprivation of liberty issues as they arise for young people. And that inevitably brings us to the crossover between the court of protection, the family court, and the inherent jurisdiction. So just to give you some idea really of the questions that should be asked. Now, when I talk about transitions and teenagers, the areas that we're looking to really are the ages from 14 upwards, because that's the age at which certainly the NICE guidance suggests that transition planning should start to take place. It's also the age that within the education sphere, there should be some transition planning taking place. And really, it would be useful to think about teenagers transitioning from about the age of 14 up until 25, which is the age at which various obligations of the state towards young people expire. And I've given you on this slide some of the questions that it's sometimes useful to ask and to think about in terms of which public body you should be looking to for the responsibilities and the obligations. What the specific vulnerabilities of the young person is, and there's a whole complex raft of issues that can arise. These can be young people at risk of sexual exploitation, they can be at risk of the county lines and criminal activity, which brings its own problems. They can be, not always, but sometimes are care experienced young people, which might bring its own set of responsibilities of the state. So there's a lot really for practitioners to be aware of. We also have to ask ourselves about the young person's capacity or competence, referred to more usually as competence for younger children, but over the age of 16, as we'll come on to in due course, a young person can be considered to lack mental capacity within the meaning of the Act and find their case before the Court of Protection. And one of the difficulties that I'd suggest that we have sometimes in working with this age group is that there is a natural, what's referred to in some of the case law as a paternalistic, the protective impairment, to try and look after and make decisions for this group of young people, when actually it may be that they are perfectly able to make those decisions themselves, but they're simply making unwise ones, but they should be allowed to have that autonomy to do so. And that's sometimes a tension really between children's social care and the adult world that they're moving into. So the way that we tend to be helped to think about this is to just have a think about the background and see where the issues have arisen from. And I set out for you that children's services were split away from adult services in terms of social care back in October 2002, and with a plan to really create some specialisms around children's safeguarding. But the consequence of that is that we now have in some local authorities, certainly not all, but in some local authorities, distinct teams. And if there isn't a transitions team at that local authority, sometimes things aren't particularly well joined up. And that's certainly my experience when it comes to cases. We've also got the situation that for families who are navigating this time in their child's life, they feel very much that they sometimes reach a cliff edge, so that there are separate teams, different thresholds for provision being put in. There's certainly very different approaches taken, for example, between CAMS and then adult mental health services. There's a different means sometimes of funding matters around personal budgets and direct payments once a young person reaches the age of 18. So if it's complicated enough for professionals to look at the services across the board, for families living through it, it's extremely difficult. And that's why it's so important that any practitioner in the area has the knowledge base to try and at least join the two worlds together effectively. In terms of the legislative framework that we're working in when we talk about transitions, there is a host of overlapping legislation, as I'm sure you're all aware. We have the Children Act 1989 as a starting point, which I think for those of you that are children's practitioners will be the go-to area first of all. And within the Children Act and within that framework, it's necessary to think about how the child's known to the local authority. So are they subject to a care order, be it interim or final? And that's relevant when we come to look at issues around parental responsibility. Have they been voluntarily accommodated under Section 20? And if so, which part of Section 20? Because some of the law around secure orders, for example, draws a distinction between different types of accommodation. Have they been remanded within the criminal justice system, which would mean that they become a looked after child by virtue of their remand to local authority care, but maybe it's a slightly unusual route into care. And if they're not a looked after child, are they known to the local authority in any other way? Have they been subject to child in need plans, child protection? So really, I would suggest a useful starting point when faced with a case that's perhaps involving a difficult placement for a mid to older teenager is to think, well, how is it that the local authorities got responsibility for them on what level? We then have within this diagram things such as the Children Leaving Care Act 2000, which imposed the obligations for the first time on local authorities to have for care leavers a personal advisor appointed, a pathway plan, terms that a lot of us are very familiar with by now. In terms of care leaver duties, of course, and this is relevant to both the regulations and the 2000 Act, A child's a care leaver if they've spent time in care after the age of 14 and that spans their 16th birthday, with a period of time from 13 weeks or more is the definition. So if a child spent 13 weeks or more in the local authority care under any sort of regime, after their 14th birthday up to the point of their 16th birthday and beyond, then they're entitled to the leaving care duties. So that opens up one avenue of support for them, potentially. We've also got within this, though, as you can see, issues around the Mental Capacity Act 2005, which is relevant to all young people over the age of 16 if they lack capacity. And then we have the Care Act 2014, which has its own distinct transitions section and transitions assessments to be carried out. Also relevant, and I've included here, we've got the Children and Families Act 2014. Now, that act particularly makes provision around education and revised the previous Statement of Special Needs plan, and we now have education and healthcare plans under that 2014 Act. And then finally, most recently, the Children and Social Work Act 2017, again, which has its own section on transitions. So you can see already the whole plethora, really, of various different pieces of legislation. I've just been asked, what about if they become looked after the age of 16? Is it the same 13 weeks? It is still 13 weeks. It doesn't have to be 13 weeks in one block, but after they get past the point of 13 weeks, they then hit that definition. So that would, the reason I say that is because it's time spent in care after the age of 14. So obviously being older than 16 takes you past that point. And they will have been in care after their 16th birthday. So yes, you're looking for that 13 weeks. Obviously, the local authority, that's not to say that they can avoid responsibility. If it's a shorter period of time, they will still be classed as a looked after child. But for the purposes of strictly the care leaver duties within the Act, yes, it would need to be 13 weeks. They still count as a care leaver, even if they return to parents, if they spent that 13 weeks up until and beyond the age of 16. So if they're to return home at the age of 17, that's fine, but they still count as a care leaver. The next thing to maybe think about, and we'll move on to the individual parts of the legislation, is who has parental responsibility. I'll come on to that slide in a moment about the Care Act, but if we just a word about parental responsibility, because this depends largely on the presence of care orders, and it can be complicated sometimes if it's, for example, an adoption breakdown or a special guardianship order type breakdown. The question of parental responsibility isn't always obvious. If the local authority don't have parental responsibility and you're talking about a case of a 16-year-old who's not been in care previously, under a care order, then you need to question whether or not they should have it. Do they need it to share that PR? And obviously remember at all times that care orders can only be sought up until the age of 17 years old. And if there's any interim proceedings ongoing at that point, the interim care order falls away at the 17th birthday. That comes from a case in 2019, the REQ case. And the thinking behind that was that, if I can call them the old days, before 2014, we had a system whereby interim care orders were only made for periods of 8 weeks. So they wouldn't have continued for the 12 months after a young person's 17th birthday. It would have come to an end naturally. That system's obviously been revised, but the court in REQ decided that interim care orders will come to an end. Doesn't necessarily mean that if you're in care proceedings, the whole proceedings come to an end. If there are welfare grounds to continue, for example, you're exploring support networks, then they can continue, but you wouldn't have the interim care order. So that reduces your options sometimes when looking at what's needed for older teenagers. If you're looking at what's needed for a 16 to 17-year-old, the clock is ticking in effect until they get to the age of 17, because you can't then have the care order. Obviously, if a final care order is made, it runs up to the age of 18. I would suggest that with all of these situations, and it's probably a good starting point for most cases, you start from a needs-based approach. What is it that this young person is presenting with, and what would meet that need? And then you look for what legal framework would best govern that, rather than trying in some way, which does happen sometimes, to say, well, we think we need a particular sort of order, and then fit the child's needs around it. Let's start from the needs-based approach and see where that takes us. I think before we move on to the Care Act and the other statutory duties, because I don't want to just leave the Children Act just yet. This is contained within your narrative handout when you get it. It's not on the slides, but it's just worth maybe having a think about Section 25 orders under the Children Act and secure accommodation, because this has been a real difficulty recently all over the country in terms of a lack of available secure welfare beds. And I'm sure there's those of you amongst the delegates who are well aware of the difficulties in seeking secure beds and the lack of provision that's simply available. The age range for secure orders, just by way of reminder, is that a child under 13 years old can only be placed with specific approval from the Secretary of State. So they form a distinct category and you have to refer to the guidance for that. But they can be made up until the age of 17, and once a young person is 17, and that's been confirmed now in the case of RES from 2015. So secure accommodation orders are available as a remedy if they're needed, up to and including the age of 17. And it's been long accepted for a very long time now that if the secure criteria in Section 25 are met, then that's the order that should be made. Just in terms of the criteria though, I thought it was worth mentioning that you have the statutory criteria, which is probably familiar to most of you, in that they either have a history of absconding or they're likely to abscond from any other sort of accommodation, and if they abscond they're likely to suffer significant harm, or that if they're kept in any other type of accommodation they're likely to injure themselves or somebody else. So if a young person falls within either of those two categories, it's possible to apply for a secure order if you actually have the accommodation available. There's been recent consideration though of the criteria back in 2019 in the case of RE-B, and please don't worry about any of these references because they are all in the handout, which says effectively that in addition to those statutory criteria, the court should also consider whether or not the proposed order safeguards and promotes the child's welfare. So you're looking at both welfare and also proportionality. Do the benefits of the proposed placement outweigh the infringement of rights? And those are additional matters, because sometimes a young person might meet the statutory criteria, but there are concerns that actually that's not going to meet their welfare needs, and then some difficult considerations will have to be made about what sort of application you make before the court. It's worth remembering now that thanks to some amendments through the 2017 Act, the Children and Social Work Act, that Scotland is now available in terms of secure accommodation if it's accommodation approved by the Secretary of State, that placements can then be approved in Scotland. And that followed some issues described by Mumby in the REX case, and amendments were made. So secure accommodation, care orders, those are the orders that are familiar to most family practitioners and are available for young people at around this sort of age. Let me just check any questions before I move on from secure. We'll come on to deprivation of liberty. Don't worry, I'll come back to that. Yeah, I've just been asked, just going back to the definition around care leaver as a whole, and any pre-planned short breaks. A pre-planned short break doesn't, as of itself, count within the looked after child period. So if it is pre-planned and it's respite, for example, you see a lot of this in disability cases where parents have arranged some respite, that wouldn't necessarily count towards your 13 weeks for care leaver duties. That's not really what the scheme's aimed at, because it's respite breaks and short breaks are excluded. I think a view has to be taken as to whether or not those short breaks become so regular that actually on the ground, this is becoming a more prolonged period in care. So sometimes I think labels can be used to differentiate between the two, but actually what's happening is that this is a period as a looked after child. So I think it's always useful to look at the concrete situation on the ground. But it's certainly, if it's a short prearranged weekend away, then no, that wouldn't ordinarily count towards it. I've just been asked, does the amendment I've referred to apply to the Welsh secure use of Scottish secure estates too, please? I'm going to really infuriate the Welsh listeners amongst you in that I'm going to have to check Welsh matters, as I'm not a regular practitioner over there. I don't think there was any difference drawn. So yes would be my answer, but let me check. I'm going to keep a log of Welsh matters, if I can put it that way, and I'll come back to you, Kerry, if that's all right. Right, shall we move on to the Care Act then, and have a quick look at that? And in saying that, I'm very well aware that the Care Act, of course, is the English terminology. Wales has its own legislation for this, although the provisions do largely mirror each other, as I understand it. So within the Care Act, the Care Act was set out to pull together, I think, upwards of 60 pieces of community care law, which had been identified as all overlapping and being extremely difficult to navigate for practitioners. So we were told that we'd have the Care Act 2014, which would effectively draw together the various duties of a local authority when we're looking at community care sections. Obviously, this talk is limited in that it looks at transitions, and there are a variety of different assessments which local authorities are required to carry out for young people who are going to have needs or identified as potentially having needs once they turn the age of 18. And the 2014 Act says that if a child, young carer, or an adult caring for a child is likely to have needs when they turn 18, the local authority must assess them if it considers that there's a significant benefit to the individual in doing so. And it's always worth asking, if you're a practitioner in a childcare case and you have a young person, 16 or 17, who it's clear is going to have extra support needs when they turn 18, it's always worth requesting that a Care Act assessment is carried out at that stage. It may well be that a joined up one can be done with children's social care. That's perfectly permissible, and indeed encouraged, in that the young person only has to tell their story once. So, but it's worth asking for sight of that assessment if you can. The Care Act, as I've said, gives various different sections, and you have also the Care Act guidance, which I've given you on the screen, and the regulations. They are, particularly the Care Act guidance, is updated, so it's always worth checking that you are working to the most updated version. And when you have the handout in front of you, it gives you the various sections of assessments of need and the like. So in terms of when there should be an assessment under the Care Act, I've just told you the trigger already. If someone's likely to have needs for care and support, then they should be assessed, but the timing depends on when it's of significant benefit. If this is a case which is before the court and you're in receipt of children's services and there are issues, then it's very likely that there should be one carried out. And these are the factors that the local authority has to consider about timing, effectively. Whether or not it's going to disrupt school, what the young person's wishes are. Clearly, consent and compliance with this age group is sometimes of a huge difficulty. And it depends very much the sort of case you're dealing with. If you are dealing with a case with a young person whose needs are such that they are edging towards secure accommodation or deprivation of liberty issues or CAMS support at a significant level, then it might be that it's really not the time to be looking at a Care Act assessment, and you have to wait until things are more settled. But that's not to say that it can simply be ignored. It needs to be borne in mind. The other aspect that it's worth just joining up the dots with, and this is why really transitions becomes something of a web of overlapping areas of law, is that it's always worth, in my view, having a regard to the education and healthcare plan. which may or may not be in place. This might be a young person who's been out of education for some considerable period of time, isn't engaging. But the local authority does have a duty to look towards their education and to support that. And education can be taken to mean in its widest sense, not simply classroom learning, it's taken to be the holistic life skills. So there's again, a need really for an awareness amongst practitioners, and what use you put it to in any particular case will vary because of the whole range of needs of young people out there. But it's worth having a mind to that and to the education side of things for young people, as well as health, obviously. I'll say a bit more about education in due course. In terms of the content of Care Act assessments, it's all set out within the guidance. What is important is that they can and they should be joined up with other assessments if it's ongoing. And the adult social care team can draw on the content of those other assessments for their Care Act assessments. So it's just worth having in mind. So we're going to move on. Pause for a minute and see if there's anything arising from that. I don't think there is. I've been asked specifically to have a look at ordinary residents with you this afternoon. As an area that I think does cause some problems sometimes for transitions cases. And it's an area in which sometimes it's thought that, and rightly in some cases, that the arrangements that are put into place for a young person as a child may well carry on through in terms of funding and obligations for local authorities into their adulthood. And that's an important matter to bear in mind, particularly if you're either employed by a local authority or advising a local authority. It doesn't, of course, change that young person's needs, and the emphasis from the court is always to make sure that those needs are met first and foremost before you look at considerations around cost. So in terms of ordinary residents, the children practitioners out there amongst you will probably be more familiar with the idea around habitual residents. Which is something that children practitioners are used to talking about, and is of course a concept that applies to cases with international elements as well as domestic ones. Ordinary residence is slightly different in that it's a statutory concept, although the two overlap to a large extent. And we had the classic test set out for ordinary residents in the Shah decision from 1983, so going back quite some years now, which talked about a man's abode in a particular place or country being that which he'd adopted voluntarily and for settled purposes. And for children, particularly young children, their ordinary residence will usually follow that of their parent, albeit that they're not capable of making the independent decisions themselves. We obviously see these issues come up a lot in delegated authority arguments between local authorities as to who would be responsible for young people's needs under the Children Act, be it in the form of a care order or any other source of support. And the Children Act as a starting point gives us some deeming provisions within section 105, which effectively says that when considering the ordinary residence of a child, you have to disregard the period of any time spent in care or dealing with the requirements of a supervision order or being provided with accommodation by a local authority. And that really means that when you're looking at ordinary residents, you look for the young person's ordinary residence before they were placed. So if they're placed out of area, which a lot of this age group are, sadly, away from family members, which again comes back to resources, but you are left looking at the responsibilities of the placing authority, where they were before they were placed. And the context for that is obvious in that it then enables that authority to take those decisions without a future local authority saying, well, no, we don't want our resources being used in that way and we can't afford it, for example, we're not going to commission it, which would then leave that young person's needs unmet. So you look to the placing authority to meet the obligations in the first place. That is very similar perhaps to designated authority arguments when we look at trigger events and where it is that the trigger event took place, when we're arguing about responsibility for a care order or for proceedings. So we have the Cornwall case, which was a Supreme Court decision. And again, I've given you more details of this in your narrative handout. And this was the case in which a young person had been, or a child in fact, when the case, when you look back through the case history, he had been ordinarily resident in Wiltshire as a child. They'd arranged a foster placement for him in South Gloucestershire. So Wiltshire retained ordinary residence when it was decided by the Supreme Court. His parents had moved to Cornwall, and the Secretary of State had initially said that ordinary residents could pass to Cornwall with the parents, although that young person had never lived there. He'd visited, I think, once. And the Supreme Court said, no, it goes back to Wiltshire, even though that had been quite some time before and no member of the family was, or immediate family, was resident there at that time. And when you read the judgment, you can see that actually that came as a bit of a surprise to all parties, because nobody was contending that it should have been Wiltshire. And to transfer this over to adults, we then have the Care Act, Section 39, and that also makes deeming provisions very similar to the Children Act. So the Care Act tells us that an adult is to be treated as ordinarily resident in the area in which they were resident immediately before they started to live in accommodation. And there's certain types of accommodation that this applies to, including supported living and residential. So you can see that the two things are mirrored, really, whether it commences as a child or commences as an adult. That's the theme for ordinary residents. There's been some recent consideration of it and some difficulties that arose last year. And it may well be that this is the reason why we had a particular request for this area today, in that there's the case of Worcestershire County Council and the Secretary of State, in which the Secretary of State actually said that he thought the Care Act guidance was wrong. That's gone to judicial review, and the High Court has disagreed and has said no, it remains with the original placing authority. So effectively everything that we've just been talking about, but the Secretary of State is appealing that decision. So this is still a developing area of law. There aren't that many cases that reach the senior courts on ordinary residents, but when they do, they obviously have significant cost consequences for local authorities all over the country. And it's a case that on any specific set of circumstances can become increasingly complicated. So we have to watch this space for the outcome of the case from earlier this year. But in the meantime, we have the High Court decision that tells us that even where there's been, for example, mental health detention in different areas of the country, you look back to the original placing authority for their responsibility. So that's the current state of the law in that respect. Right, let's move on then and come back to the legislation, which is around the this age group in effect and transitions. So I told you earlier that the Care Act was intended to pull together the variety of different community care pieces of legislation. We then, in the very same year, had the Children and Families Act 2014, which has its own section on transitions. And unfortunately, the two pieces of legislation don't refer to each other. There's no crossover between the two. They each have their own transitions provisions, but it's perhaps unfortunate that that wasn't joined up. I'm just being asked, just bear with me 1 second, is that the same with adoption if that breaks down? Adoption, I think, Julie, is perhaps a more distinct area, because in that case, the legal parentage will have moved and questions around parental responsibility and the like will have moved. So I would say that's arguable that it's not, but again, it's probably something we'd have to look at on a case-specific basis. I think because of the legal nature of adoption and the fact that it severs parental responsibility and the local authority don't maintain that responsibility, but that's potentially arguable that the child's resident with their adopters in a different area and that you start afresh in that second area. But again, that's just the sort of complication that does arise in these cases. Right, forgive me, coming back to the Children and Families Act. So we had the act that refers now specifically to the idea of staying put, and staying put was a policy which some of you will have heard of, this idea that post 18 children that aren't in the care system don't suddenly sever ties with their parents. they continue to have homes to go to, whether they're in further education or elsewhere, family homes to return to. And the intention behind the staying put policy was that care leavers were afforded that same family network in effect. So this is the act that puts matters to do with staying put on a formal level. It also, of course, revised the special educational needs system, which is, again, that could be indeed the topic of a different seminar all of its own. But it provides for the local authorities' duties to assess education and healthcare needs in the plans that you'll be familiar with. And then just finally on legislation, yes, I've just given you there the, it's a useful link actually, that just compares the obligations of local authorities under the Care Act and the Children and Families Act, given that they came out in the same year. And as I say, they're not cross-referenced, so that's it's a useful guidance document within that link. We then had more recently the Children and Social Work Act 2017, which again deals with transition. And this is again a growing body really of legislation around transition, and this sets out and extends the duties of local authorities for care leavers up until the age of 25. So whereas it was previously up to the age of 21 for further education support, now if a care leaver informs the authority that they want to receive the services until they're 25, then they can do. I would argue that it's potentially a missed opportunity to limit that to only those care leavers who request the support. One of the huge difficulties for researchers in this area and those that look at life outcomes for care leavers is that any longitudinal study with care leavers is incredibly difficult in terms of keeping up contact with them and keeping their engagement. So the idea that only care leavers who request that support can benefit from it and are entitled to it perhaps seems rather difficult, given that this is a cohort that we know struggle to engage at times. But clearly it's of benefit that at least the statutory provision for education support goes up now to the age of 25. Just in terms of education, I've mentioned it briefly, it obviously plays a huge part in these transitional cases because these are crucial years for a young person in terms of their education, and recognising this is sometimes a difficult age group, they may have dropped out of education completely. So it's just worth bearing in mind that you have not only the Children and Families Act, you also have the SEND regulations and the code of practice that go with that. And you have to think about within that issues around representation at the tribunal, representation in terms of asking for a plan and considering changes to that. But if in doubt, you've got the code of practice and regulations to refer to. And it's also just important to remember that some of the concepts that we talk about in terms of deprivation of liberty and capacity are equally relevant if the young person has a case before the tribunal. And I've certainly had cases where family members are in the Court of Protection, they are dealing with the educational tribunals as well alongside, where family members often represent themselves. And they may have other issues going on in terms of family court procedures. So sometimes families really are put through the mill in terms of the variety of different arenas that they're expected to deal with matters in. And it's incumbent then upon the practitioners to have an awareness of them and try to pull those threads together. Which brings me nicely on, really. I'm going to leave these slides just because I've already covered it. To the overlapping court jurisdictions that we have in this area. So we've looked a little bit at the whole myriad of legislation which is out there. We then also have four, if we include the first tier tribunal, of different types of jurisdictions for these cases to think about. And post the age of 16, if a young person lacks capacity to make specific decisions, for example, who they should have contact with or where they want to live, or any other decision, it's fair to say, if they lack capacity, then the Mental Capacity Act 2005 has jurisdiction from the age of 16, and their case can be dealt with by the Court of Protection. There may well be cases where a young person is considered for whatever diagnosis that they have, because it needs to be a diagnosis for court of protection proceedings. Whatever the diagnosis is, they may have lack capacity in respect, for example, to contact. If they're making decisions around contact with a boyfriend, for example, who's putting them at risk, but they might have capacity to decide where they want to live. So there's a whole host of very decision-specific and time-specific complications to capacity. The starting point, I would suggest, when you have a case to advise on or to deal with, as a social worker, if you're presented with a young person's case, is to think about, are they competent? Are they able, within the Gillick sense, to make that decision themselves? Do they have capacity? And that comes back to looking for a diagnosis of any mental impairment. And capacity assessment is a subject in its own right, which is a specialist matter, which I'm not going to go into because we spend the afternoon looking at that. You may also have a young person who has capacity, in which case their case falls squarely within the family court. And then you may have those that don't want to be assessed and that you haven't been able to carry out an assessment of because they simply won't engage, but you know that there is a diagnosed learning disability and that there are real multidisciplinary concerns about their decision making and what's happening there, and you need to assess them. And sometimes the right forum for that can be into either the Court of Protection or the inherent jurisdiction to look at the capacity issues. In terms of who carries out those capacity assessments, that's done either by a children's social worker if they've got the right training and they feel confident in doing so. Capacity assessment is a skill in its own, as I say, in its own sphere, and there's a whole host of guidance out there and case law from the Court of Protection about how to assess capacity. Quite often children's social workers will ask for the involvement of the adult social work team on that basis so that a proper assessment can be carried out. The capacity assessments can also be carried out by GPs, by mental health nurses. There's no difficulty with that. Sometimes the Court of Protection requests that it comes from psychologists or psychiatrists, but it depends on the level of difficulty that you're looking at. And the usual starting point is with either social care or a registered mental health care nurse if that's the level of input. It depends on who's been best involved really with that young person. Now, it is possible for cases to move back and forth between the Court of Protection and the Family Court. And there's a legislation, a statutory instrument that provides for that, which I've given you on your screens. The best way maybe to think about it comes from the decision of Sir Mark Headley back in 2011, where he considered transferring a case and spelt out the principle. So if the child's over 16, that has to be, otherwise the Court of Protection just doesn't have jurisdiction. Do they lack capacity, as we've just talked about, in respect of those specific decisions? Are there disabilities which give rise to that lack of capacity? Because that's the second part of the test. And when thinking about it, can all the decisions which arise in respect of the child's welfare be taken and resolved during the minority? So, for example, in a case where a father has applied for contact under a care order, so a Section 34 application, with a son who's in local authority care and he's 17 under a final care order. But actually the issues in the case go much beyond just the father wanting contact. What he really wants is to take his son home, and he thinks he can do that when he turns 18. But this young person is in a residential home with physical disability, and there's a dispute about what's likely to be in his best interest. Now, that dispute is not going to be resolved by the time that young person reaches the age of 18, and it requires a court that can make decisions for him on his best interests going forward into adulthood. So those are the cases that flags should be raised that you think, no, this needs to go into the Court of Protection instead. And it can also transfer back the other way from the Court of Protection to the Family Court. I think that's more unusual, and that's not something that I've particularly come across, but it is possible. And this is another example, really, of a decision taken by Mumby when he was in the High Court, who thought about whether or not to discharge care orders and move into the Court of Protection. or I think in fact this one was into the inherent jurisdiction, and he took the decision that no, because he wanted the guardian to remain on board, and that's another significant concern if you're moving between jurisdictions, so that you keep continuity of guardians and judges as well. Very well, so that moves us on really as capacity. As I say, these are all issues that are substantive in their own right and need proper consideration when they come in. But when you're looking at any young person's case, competence and capacity, even just taking a preliminary view as a social worker and thinking about it in terms of Gillick competence, are they able to make that decision? Or is there an underlying diagnosis which is impacting upon them? It has to be considered. Right. The next slide is on deprivation of liberty, but I'm actually just going to deviate from that slightly because I want to give you the framework for this. So more and more recently, we are certainly seeing, and I think it's the experience across the country, we're seeing an increase in issues of a lack of resources in terms of secure beds or CAMS beds if mental health treatment's needed for teenagers into adulthood. And there's been a number of High Court cases, which are on the slides later, which have highlighted the gap in provision of care, basically. And where there is a gap, it is sometimes necessary to apply to the High Court, which has jurisdiction over young people, children and adults, all the way through to whatever age the person is lucky enough to live to. That the inherent jurisdiction of the High Court can make decisions that are far-reaching and cover all ages. So it's a very flexible jurisdiction in that way. It is commonly used in respect of children for matters around abduction or medical treatment, those type of instances. But it also gives you the safety net, as it's sometimes referred to, that where you can't achieve the outcome that you feel you need to for a young person in this scenario, through any other means, so say you've exhausted secure accommodation lists, you are being told by NHS England that there are no mental health beds that are available or suitable, there is no other route to go in order to keep a young person safe, then it may very well be necessary to apply to the inherent jurisdiction of the High Court for an order. Now, the type of order can, again, be really wide-ranging. Sometimes we apply for orders that involve injunctions against third parties to try and prevent unhelpful associations. So say, for example, you're a 17-year-old teenager who wants to go and sleep in a car with her boyfriend in the woods, and that's where she wants to live from now on. And there's a learning disability in the background, although it's difficult to assess because she doesn't engage properly. And there's some concern about what's actually going to keep her safe. The local authority have care duties towards her. Now, those sorts of very difficult grey areas, you can apply for injunctions against third parties. You can apply for what's known as the authorisation to deprive someone of their liberty in a placement. You can also equally, and we'll talk a little bit about this at the end of the seminar of this time, you can apply to have the child made a ward of court, which vests all important decision making in the court. So there's a variety of different ways in which you can tackle it. One of the orders that the inherent jurisdiction can make will be to authorise the young person's deprivation of liberty. And that brings me on to this slide. All right. So the reason I talk about the inherent jurisdiction is to let you know that it's there as a safety net. You can only use it. Bear with me, I'll go back. If the means, effectively, if the ends can't be achieved in any other way through any other statute, and that comes from Section 100 of the Children Act. So it's quite a restricted access to it, and you need permission to invoke the inherent jurisdiction. So it's not entirely straightforward. But if all other avenues have been exhausted, it is sometimes the only way. Bear with me, I'm just checking the Q&A. Right. So, deprivation of liberty, what is it? We have a fundamental right to our liberty and security under Article 5 of the European Convention on Human Rights. And when you have the narrative handout in front of you, it will set all of that out. in terms of the Article 5 rights, which is the starting point. In English jurisprudence, the way the law is developed is that someone's deprived of their liberty if they lack capacity, if they're subject to continuous supervision and control, and they're not free to leave their placement. Now, a lot of that applies more easily to adults, and there's been some case law, which again, I'll give you in the handout, which points out that many children aren't free to leave their placements in a usual everyday setting with parents. So we have to adapt this to young people and their needs. The placement's also got to be what's referred to as imputable to the state, which basically means that the state has to be aware of it. It's a very low threshold for state involvement, and that's known as the acid test from Cheshire West, which some of you, no doubt, will be aware of. In terms of a young person's ability to agree to these things, so this comes back to their capacity, because capacity doesn't refer to a general theme, it's capacity to make the decision to agree to either these restrictions or to make decisions about their accommodation more generally. We've now got the Supreme Court decision which looked at who can actually consent and who can give valid consent. And the Supreme Court was satisfied that once a young person reaches the age of 16 years, if they don't consent themselves or they can't give valid consent because of their mental impairment to a deprivation of liberty, then only the court can do so. And that reversed some of the earlier decision making, which said that parents could exercise their parental responsibility to consent for over 16-year-olds. That's no longer the position. So as of Re-D in 2019, if a young person is over the age of 16 and a local authority placement is going to deprive them of their liberty, the court's authorisation will be needed. At under 16, if there's no care order in place, then parents are still able to agree to deprivation of liberty, unless there's any dispute really between the local authority and the parents, and if there is, then it really does need to be referred to the court for authorisation. So consent in this area is always somewhat tricky. If there's a care order or interim care order in place, then it needs to be referred to the court because the local authority can't agree to it and neither can the parents. And that's been established as well in authority. So we have a fairly settled picture now in terms of deprivation of liberty. It took from around maybe 2014 onwards that we had this developing line of case law, but a lot of the answers have now been given to us by Re-D. In terms of what amounts to a deprivation of liberty, which is of course the first question that you might be asking yourselves, the Law Society produced some guidance. It's some time ago now, it's back in 2015, but it's still very relevant, which looked at what a deprivation of liberty might look like in some worked examples for young people, which is still a useful tool. We also then had the decision of Re-AF, which was Mumby-J's decision in 2018. And he refined really the acid test that I've just given you and adapted it to young people and said, well, we have to apply a rule of thumb here. It will be very different, for example, a 10-year-old in terms of deprivation of liberty, because 10-year-olds are more ordinarily supervised in the community. They wouldn't usually have a door key maybe, or some might. That's the sort of decision that we're looking at. But as the child gets older, if a 16 or 17-year-old doesn't have a key to the premises in which they're living and they have 2-to-1 supervision when they go out in the community, that's far more likely to be recognisable as a deprivation of their liberty, because it isn't what another child of their age in the usual family setting might have. So those are the comparisons that you're making when you're asked to look at, is this placement going to deprive them of their liberty? Things around continuous supervision and control. What's the level? Do they have access to all parts of the accommodation that they're living in? Can they access the kitchen in the middle of the night if they want to, as they could if they were at home? Are there parts of the kitchen, for example, the knife drawers, that are locked? Those type of things. And you look at the package as a whole to say this is now becoming beyond a reasonable restriction and straying into deprivation of liberty. In terms of consent, we've said a little bit about who can and can't consent to deprivation of liberty. Just keeping an eye on the time a little bit. There's been a lot said about the young person's own consent to this. And in a case called Re-C back in 2016, Key and J found that he didn't need to authorise the deprivation of liberty because the 16-year-old was agreeing to it themselves. Now, the official solicitor in that case raised some concerns about that being slightly problematic, and the difficulty there is maybe obvious that for this, particularly this age group, but probably for any young person, what they might agree to on one given day may well change the next. And actually, if they know that if they don't agree to this, the next step is going to be secure accommodation, is that actually proper valid consent? In the really free informed position, what are their options? They're agreeing to something without knowing that they've really got any other valid alternative open to them. Quite often these placements are a placement of last resort and there is nowhere else to go. So consent as itself is a slightly troublesome aspect. As I say, K&J decided in Reese's authority to say that we don't need to authorise deprivations because they're in fact not deprivations if somebody agrees. And it might well be said in cases that there isn't therefore a need for authorisation where there is consent. But it might be worth just bearing in mind, if that comes up in a case, that other jurisdictions, for example, in the mental health world, there's been a decision of the Supreme Court, known as MM, and as I say, you'll get all the references, so please don't worry, but a decision from 2018 of MM in the Supreme Court held that a patient couldn't consent to conditional discharge if those circumstances amounted to a deprivation of liberty, because in effect they had no other choice. If they didn't agree to that, then they would be recalled. So it's questions again around valid consent, and it's just worth looking at that a little bit more carefully rather than saying, well, they agree and therefore we don't need it. I've been told recently, for example, of an instance in which a judge had said that they don't need to authorise a deprivation of liberty because the young person agrees, and that the restrictions can be set out in a written agreement instead with that young person. That was then done on the basis of the judge's decision, and within a week the young person had revoked all agreement and the matter had to come back to court. So it's often a difficult area. Just to bear in mind, everything I've just said about 16 to 17-year-olds is subject to some changes next year. So those of you that work within the adult world of adult social care will be aware that deprivation of liberty is, and the safeguards that we currently have are moving to the liberty protection safeguards, and I think the implementation date we have at the moment is next April, although it's been a bit of a moving feast. Now, within that will mean that there will be a whole scheme to authorise the deprivation of 16 and 17-year-olds, like there is now for 18-year-olds and above. And it will be encompassed within the new administrative scheme. So there won't be a need anymore in those instances for court authorisation, and any challenge will be taken through the Court of Protection instead. So just bear that in mind. There are changes afoot. And the new scheme and code of practice will be implemented next year. In terms of what that means for family practitioners, it's likely to mean that cases where there are concerns around capacity, or there's been a finding or an assessment of a lack of capacity, are dealt with under the new administrative scheme. And only those instances where capacity is not so clear will fall still to the inherent jurisdiction and the family courts. So that may well be a slight difference in cases that come to you. All right, I'm just being asked, as a 17-year-old currently in a placement where she was subject to a DOLS due to recent presenting suicidal ideations, concerns around capacity now, can a DOLS still be applied for? Yes, and should be. So if there's a deterioration in presentation, the authorisation can still be asked for, because effectively that care package is likely to become, I would imagine, more restrictive rather than less. So the very fact that the previously authorised deprivation of liberty is now going to be increased will mean that, yes, the court will need to continue that. Then followed up, of course, with the comment that the placement have now served notice, no doubt because of the increased level of need, or at least contributing to that. Which brings us on to what we're going to look at in a minute, to unregulated placements and where that may then have to go. Clearly, resourcing placements at the moment, and it has been now for some years, even though I say at the moment, has been a long-standing issue for some difficulty. In terms of expiry of deprivation of liberty, it's important to remember that the reason we have to seek court authorisation of deprivation of liberty is in order to make those restrictions lawful. So if there isn't a valid authorisation, but the young person is still being pupil unsupervised, there are other aspects around the deprivation of liberty and it is still a doll, but no valid authorisation, then potentially there could be a claim for an unlawful detention in the future to say, well, I was deprived of my liberty and you should have had it authorised and you didn't, local authority, and therefore the actions carried out to restrain me or to supervise me, etc., have been unlawful. Now, quite often, if it's a minimal breach, if I can put it that way, where nothing would have changed on the ground and they would have stayed subject to a dole, then it's a question of very nominal damages, if at all. It's really those cases where there's been a fundamental breach. So say, for example, the case involving Essex County Council for some years ago now, that effectively moved an elderly gentleman from his home and took him into a care home for a series of months, I think around 13 months, without ever having that authorised. That's far more significant. So the impact of the previous deprivation of liberty having expired, as I'm told, is a problem in this particular case. Has to be looked at in terms of what the options are, but clearly there has to be some authorisation and there has to be some placement for them, which is the more fundamental problem that we're all aware of and all battling with. I can see that there are, I think, 3 things arising in the Q&A, which for some reason I don't have access to. So I wonder if those people that are using the Q&A would mind just moving over to the chat function instead, which I can deal with more easily. Forgive me, I'm not sure why the Q&A is not accessible to me at the moment. I can see there's 3 comments, but as I say, if you want to replicate them in the chat, then I'll try and pick them up as we go along. Right. So, forgive me if this isn't particularly easily readable for you on screen. It might be easier once you have the hard copy in front of you, but this is a flow chart which attempts to set out the various different routes and questions to be asked when you're thinking about deprivation of liberty. Starting point is it actually a deprivation of liberty, or is this support? And there's a variety of different authorities that look at that, but actually they all come down to being very case specific, and you have to think about what's happening on the ground for that young person. There's no real rule as to that. You have to look at the package as a whole. Be aware that within the children's homes regulations, there is scope, for example, for a young person to be restrained or to have their communication limited in the form of removal of mobile phones, and to have contact with family members supervised. That's already provided for within the regulations. So arguably, and I've certainly seen this raised in cases, arguably that may not be on its own a deprivation of liberty. It might be something that a children's home is able to do. I think once you start putting that together with community supervision or curfews or, as I say, restrictions around the home in which they're living, and you look at the package as a whole, it can raise other questions. But you have to decide first and foremost if you are saying to the court that this is a deprivation of liberty. And if it is, think about the basis for that detention effectively. Are you operating under the care order or interim or full, or is it a section 20 case, or are there other considerations like section 25 go down? And then you look at the child's age and who can give consent, which we've already talked about. So just to be aware, which I think most authorities are now, if there's an interim or full care order in place, you need the court's authorisation. Parents or local authority can't consent. The child's consent will be relevant, but sometimes problematic. If it's section 20, then provided there's a full agreement and there's no dispute between the local authority and the parents, then that can be dealt with by consent if they're under 16. All right. I'll come on to unregulated placements in a minute. I'll just have a quick look at the chat. If you just bear with me. All right, so I've just been asked about using an authorization of a deprivation of liberty to restrict social media and internet use. and whether or not that's needed if it's in isolation, that might form part of a wider set of restrictions, and then it could amount to one. Yeah, Suzanne, I tend to agree. If it's a specific, either a sanction maybe for behaviour which is seen to go against the rules, sometimes that's used as a sanction. If it's a very specific, perhaps restricting social media and internet use because of dating sites, which comes up quite a lot. If it's the type of restriction that a parent in a family setting for a young person of that age would quite reasonably impose, then it's not a deprivation of liberty taken on its own. If those restrictions then start to mount, which I think is what you mean in terms of wider restrictions, then yes, it then becomes part of a package of restrictions, and that changes the position. But just bear in mind, if it's in a registered children's home, then within their regulations, they can restrict the use of communication devices in any event, which would lead you to the conclusion that it's not a deprivation of liberty by itself. And I wouldn't usually advise to go to court on the basis of a single restriction. As I say, you need to look at actually what the question that's sometimes useful to ask is, what's that young person's life look like on any given day? For a 16-year-old, if they were able to walk to school because of geography, do they walk to school, or are they taken in a taxi or 2-to-1, for example, in a car sometimes? Are they then escorted into school because they can't be trusted to get from the gates into the classroom? Whereas a 16-year-old in any other setting would either walk themselves to school or be in through the doors themselves. So and then you work your way through, are they supervised through their break times, lunch times? Do they have somebody sitting with them whilst in the school setting? And then when they get home, what are they able to do? Are they given specific tasks to do? Are they constrained to one part of the house? It's really, what's that young person's day like? And then compare it to any other child of their age. And that when you do that, actually, and if you have a social worker write out the daily routine and who is present, it usually becomes fairly obvious if you've overstepped the line into deprivation of liberty, or if you're going to, if that's the plan. I've just been asked to clarify what regulation it is where the care home can restrict the use of mobile phones in a children's home. It comes from the Children's Home England regulations 2015. I'll check the specific regulation for use of communication devices, but I had it come up in a case the other day, so I can reasonably confidently say it's within those regulations. And I'll add the specific passage to the handout before it comes to you. Just to look, sorry, bear with me. In terms of just going back to secure accommodation orders and how they overlap with mental health sectioning sometimes. I've just been asked whether or not a secure accommodation order would continue post-release from a mental health section. My view would be that it wouldn't. It's fair to say that's not a situation I've seen come up, and I think a fresh application upon discharge from the Mental Health Act regime would have to be looked at, because, and the reason I say that is because you are looking at what's needed at that moment in time, rather than simply reverting back to the secure accommodation. And secure accommodation orders have time limits for a reason. So where a child has then been detained instead under the Mental Health Act, it would seem to me that you'd have to apply afresh. But that might be something that you'd have to look at more specifically in that particular case. I'm not aware of one subsisting beyond the life of a mental health detention. Right. Just in terms then of unregulated placements, which encompasses a lot of what we've already talked about, worth just remembering what unregulated placements actually are. So a children's home is defined within the Care Standards Act, and children's homes have to be regulated by Ofsted as a basic premise. The children's home itself is defined as, with me, a setting that's going to either accommodate wholly or in part children, effectively. So it provides accommodation for children. It's quite a broad matter, really, through the Care Standards Act. And Ofsted have set out a useful guide to the various exemptions that can be made for children's homes, and whether or not they will require registration. And again, this is something that's coming up more and more. So if you take as a starting point that a children's home is one, if it provides care and accommodation wholly or mainly for children, that's your starting point. But some establishments won't have to register with Ofsted. So say, for example, there are completely mobile children's homes, and I say this because this is a matter that's just arisen recently, in the form of a motorhome that is being moved from area to area with a young person in. Now, quite apart from whether or not that's actually in the child's best interest, it's a different issue, they may not have to register because they're seen by Ofsted as being mobile accommodation. They might be supported living, and there's sometimes a dispute between the providers of accommodation for 16 to 17-year-olds, usually 17-year-olds, who say, well, they're only supplying supported accommodation, they're not supplying the care in the sense that's made for a children's home. Although usually if you've reached the level of supervision that we're looking at in these sorts of cases, then it tips over from supported living into a children's home. So you have to be aware when placing a child whether or not the setting is regulated or not, and if it's not regulated, should it be effectively. There are other exemptions set out within the Ofsted guidance in terms of what needs to be regulated by them. Sometimes the usual course of action is to establish that line of communication with Ofsted and speak to them about it if in doubt. For example, if there are residential holiday schemes for disabled children, they don't fall within these provisions. They don't have to be regulated all of the time. If it is a very short stay, so less than 28 days, again, there are exemptions to the scheme. So it's worth looking to the Ofsted guidance for that. We've also got the President's guidance following a line of authorities which has brought out the difficulties really with these unregulated placements that can arise. So the President's practice guidance, I've given you the link to it there, but effectively Macfarlane has said that when taking a case to court, a local authority have to be in a position to inform the court as to the registration status, first of all, to know whether or not it needs to be registered in terms of the definition of children's home, and confirm that registration status with Ofsted and obtain confirmation effectively. And then the court will monitor whether or not, if registration is required, the court will then monitor the process that's gone through. Ofsted will sometimes provide a timetable to say, we're looking at this, we'll deal with it, and then you can report back to the court as to what's happening. But the practice guidance is clear that if there's been no registration and one is needed, the local authority must provide information to Ofsted within 7 days of the first deprivation of liberty authorisation. So providers have to make that application, and it shouldn't be allowed to drift by the court because they have to review it. This, I think, is the area that's coming up more and more, largely due to the difficulties in the provision. And I've given you there on that slide the various different definitions and regulations that I've just referred to. Right. I'll just have a quick look again at the questions before we come back to the inherent jurisdiction, because the inherent jurisdiction is that which operates outside of the statutory scheme. It's the inherent jurisdiction that you turn to, as I've said, for authorisation if one's needed for placements that aren't regulated. Just bear with me. It appears. All right, I'll come back to it. So we've already talked a little bit about the inherent jurisdiction and what it can deal with. It can deal with the authorisations for deprivation of liberty, as we've just talked about. It might take the form of some injunctive relief, as we've also said. And it can, as I mentioned earlier, sometimes take the form of wardship, which we'll have a little look at. All right, I'm just being asked in terms of unregulated placement. Who regulates supported accommodation for care leavers aged 16 to 24 who are considered level 4 complex needs? If that's a reference to level 4 within the CAMS meaning of tier 4, then I think it comes back to what sort of accommodation they actually need in terms of who regulates supported accommodation. If it's a supported living environment, then Ofsted don't require it to register as a children's home. There may well be registration requirements within the CQC. And certainly post the age of 18, the CQC, the Care Quality Commission, carries its own regulation requirements for supported living. So it's likely that they'd be expected to register with them. And in terms of unregulated bespoke placements within a hospital, are they exempt, and whether or not that's a matter for Ofsted or for the Welsh authorities? My first comment is that you've done well, I think, to have an unregulated bespoke placement within a hospital, because that's something that isn't ordinarily or easily set up, I think. And whether or not they're exempt, you can apply, and probably should be applying in that sort of instance, for a deprivation of liberty within the hospital setting, and they arise quite commonly with adults, where the patient isn't perhaps under the formal framework of the Mental Health Act, because that would take them outside of the DOL sphere. If they fall outside of the Mental Health Act, but they are otherwise detained within a hospital setting, then the right application is for a deprivation of liberty. In terms of whether or not it would be Ofsted approved, that they wouldn't ordinarily, I think, register settings within a hospital. But again, you might have to speak to them about that. That wouldn't usually fall within the definition of a children's home. I suspect that comes more within the mental health ambit and sphere, so to be regulated. But there is a whole host of different variations on this theme, effectively, and one of the things that's been argued about in the cases before the High Court is the need for the court to retain some flexibility and to encourage some creativity around these placements, because some of them are extremely difficult, and if there's no other setting, then things like bespoke placements within hospitals that could provide that sort of mental health input are to be welcomed. But of course they do pose their own regulation difficulties. And certainly the official solicitor has expressed some concerns more within the adult mental capacity sphere of the use of the inherent jurisdiction, because it isn't it's subject to statutory schemes and timescales and protections. So it throws up all kinds of difficult issues along the way. Right, so if we just look at the inherent jurisdiction, to just give you a little bit more information about it in the last 15 minutes or so. I've already referred you to it as being the great safety net. It addresses vulnerability effectively for those people who fall maybe outside of the Mental Capacity Act 2005. And it might take the form of injunctive relief that we've already talked about. It might look at what influence the young person is under, because some of these cases don't, well, very few of them fit nicely within one category or another. That's the difficulty we've got. We're dealing with a young person who is living through a whole range of overlapping problems, and that might mean pressure from outside, pressure from gangs, pressure from boyfriends, partners, girlfriends, etc. So the inherent jurisdiction is very commonly seen as an area in which it should facilitate decision making by the young person themselves, obviously with any assessments around capacity along the way, but to ensure that they're free from influence or coercion. Under the age of 18, it can still take the form of wardship if that's thought to be helpful. Over the age of 18, there is still an inherent jurisdiction there to protect vulnerable adults. So again, it spans, in terms of transitions and working with this age group, it spans both of them. And in terms of the protection of vulnerable adults, the inherent jurisdiction is there because we have the decision from Mr. Justice Mumby, the case of SA, dating back to 2006, which was effectively a forced marriage case, but before we had the statutory framework around forced marriage. And he held, and it's been reiterated now in subsequent cases, obviously, that the inherent jurisdiction still survives to protect vulnerable adults as and when it's needed. Just a little bit of a word maybe on wardship, because that's the other aspect that you may think about with some of these cases. You do sometimes have a case that maybe post the age of 17, so a care order can't be made. But there is still a need, not maybe for local authority to share parental responsibility, but for some court oversight into all significant decisions in a young person's life. And that can be dealt with through wardship. It effectively vests an interest in the court so that all significant decisions have to be put before a judge. Wardship as of itself doesn't provide a direct remedy to the problem. So you apply in wardship for then whatever order it is you're seeking, be it injunction, accommodation, etc. But it's there sometimes, and it's useful to consider and amongst the rest of the inherent jurisdiction picture. Now, in terms of, I'm just checking, so if there's any other points on the slides that I'd pick up on. In terms of what happens once a child moves beyond the age of 18 and using this inherent jurisdiction to go forward, as I've said here, the jurisdiction is most appropriately used to facilitate that adult's decision making, not to impose sanctions against them. And there was a case a couple of years ago, the Redco and Cleven case, which involved an injunction being made against a young person who was being discharged from a section, and it was considered not to be in her best interest to return to the family home. So the injunction was effectively made against her herself. And the court was clear that actually it shouldn't be framed in that way, not least because there were concerns about her capacity to abide by an injunction and to accept an injunction, but also because that the effect of bringing court proceedings against the vulnerable adult isn't the purpose of that. It's to put a safety framework in place around them. So, for example, it should have instead been framed that the family members were not to allow her or encourage her to reside back with them as a holding position whilst the court investigated the long-term options. And so it shouldn't be used to limit the young person's movements themselves. And it's just worth bearing that in mind. That applies equally under 18 as it does over. It's the ethos of the inherent jurisdiction. There are some limits to it, it's right to say. It's sometimes referred to as limitless within the case law, which is always slightly controversial because there's no statutory framework to refer back to, so there are no strict rules. It's judge-made law. But when it comes to depriving adults who have capacity of their liberty, which, let's face it, when we're dealing with 17 and 18-year-olds, we're on the cusp here of being an adult and able to make your own decision. So where we're looking at depriving adults who do have capacity of their liberty, there's been a couple of cases now that deal with it, and the Mazhar and Birmingham case was interesting in that was not only a case in which there was an application made to deprive him of his liberty, but it was also made without notice to him. So it was particularly draconian. And the court considered the use of the out-of-hours procedure and emergency cases and gave some guidance as to what should happen. Just in terms of that case, before I leave it completely, the court reminded us that there is some authority to say that the High Court can deprive an adult of their liberty. It's usually done in short term, and these are adults with capacity, I should add. It's usually done in very short term emergency type situations with a very short return date. And it's obviously an extremely grave step to take because you're depriving somebody of their Article 5 rights without having actually shown that they can't make that decision for themselves and they're over 18. And I think the emphasis on these kind of limits perhaps become more relevant when you're dealing with 17 and a half year olds that are edging towards this. If they have capacity, then that drive to maybe protect them has to be balanced by planning for their independence. And one thing that I would certainly say in these cases, which probably happens time and time again, is that they become firefighting cases, dealing with the immediate problem of a lack of bed in a lot of cases, whereas actually there's a need really for planning. And it's not to say local authorities don't try, of course they do, but they're dealing with what's placed in front of them. And actually from the age of 16 very quickly becomes 17, and before we know it, we're knocking on the door of turning 18 with extremely limited options. And And because of the firefighting nature of the work, quite often the actual root cause hasn't been addressed. So there's certainly a need for planning going forward with these cases, and to look the minute we start a case, perhaps with 17-year-olds, if not before, to look for what's actually going to be the independence plan and the pathway plan. Have the Care Act assessments been done? What is going to happen post 18? Because we can't keep the protection imperative, as I've said there, ongoing forever once they turn the age of 18. And this has been spelt out now in a number of cases, but I've quoted one in particular there for you. The strong temptation to grant relief in cases doesn't step away really from applying the correct law, which obviously at the age of 18 becomes very different. And I've given you there the guidance from the Mazhar case about taking cases to the inherent jurisdiction without notice in relation to vulnerable adults, and that they have to be in exceptional circumstances and for very clear reasons, effectively. Right, I'm just looking, we're coming up to the hour and a half, which I think you were maybe all expecting to deal with. So just in terms of concluding thoughts, you'll have seen hopefully through all of this that there is a whole plethora of different routes that you can take for young people. And I think as practitioners, it's certainly vital for us to have an awareness of all of the different duties, questions that we should be asking, the routes that are open to those that are working with vulnerable young people, and look at what they're actually living with as a package rather than in discrete boxes, to look at what's going to meet their needs as they mature and move into independence, if that is the plan, or if it's a case involving disabilities where their needs are going to continue to be met. What is going to be the commissioning framework? How is that going to be dealt with? Is there a need for example, court of protection decisions to be taken? I've said within the narrative handout, just to flag up really before I leave the topic completely, obviously some of these cases involve issues around modern day slavery. I mentioned in the introduction the sexual exploitation type cases, and they bring their own challenges within them because they have their own legal frameworks to deal with. It's worth remembering that with modern day slavery cases, there is the referral system to also bear in mind those interactions there with immigration and with the police to establish the difficulties and the right solution for that young person. So they have their own distinct mechanisms to look at. In terms of criminal behaviour, one aspect which is coming up, which I'll just deal with finally, and this has been looked at within the context of the use of secure accommodation orders to address problems where young people are engaging in criminal activity, but they haven't otherwise been in the care system, which would mean that they are outside the usual secure accommodation criteria, because being a looked after child is the starting point for a secure accommodation order. And that was considered. It's been considered both in terms of secure orders, but also within the inherent jurisdiction in the case of LS and others, which looked at with a 17-year-old who hadn't been previously accommodated. He wasn't a looked after child, but he was at risk of serious, possibly fatal harm as a result of criminal activity. And he was also at risk from the gangs that he was involved with and the pressure and the influence there. So this is really the very difficult to reach teenager in terms of any work being done. In that particular case, both he and his mother objected to the use of the inherent jurisdiction because the court was asked to authorise that in the place of a secure order. They both objected. And the court held that it wasn't an appropriate use of the inherent jurisdiction. In other words, it wasn't there to try and get around the problem that he hadn't previously been in care. It couldn't be used in that way, particularly where both he and his mother, who had PR consent, refused and objected to the use of it. That is a subject that is certainly crossing my desk more and more in terms of county line type applications and concerns around criminality. And in those cases, I'd say it's really important that we go back to basics and look at what the framework is that's in place. Right, I think that brings me to the end of my slides. Just a couple of, just leave you with that slide maybe for the moment while I have a quick look at the chat. Okay, there's a couple of queries raised that I'll deal with just before we close. In terms of section 117 aftercare, can they still be placed in unregulated settings? And who would apply for the deprivation of liberty where a stay in hospital is ending? If the short answer is yes, they can still be placed in unregulated. Of course, they shouldn't be in an ideal world for section 117 aftercare. But it's aftercare into the community, and if there's no other setting available that will meet their needs, then sadly sometimes it does have to be unregulated. In those cases where there's a discharge from a mental health section and it's going to be obviously dealt with under section 117, it would be useful to join the clinical commissioning group into any discussions or any court application. And what I've seen done to great effect and what we've done is where it's section 117 coming out is by involving the clinical commissioning group, you can sometimes find a bespoke type placement that then applies to be regulated by the CQC. So although it's unregulated in its creation, it then becomes regulated because you involve the regulator, in that case the CQC, to go into supported living into section 117. So that's the other thing to bear in mind in these cases. If you're social care, bring your health partners on board, be that NHS England or the local CCG, to look at actually what the options are. But yes, unfortunately, sometimes you will have to use unregulated with a view to becoming regulated in short order afterwards. And then Alison, hi Alison, has just asked who applies for deprivation of liberty where they're in hospital and the section's ending, but section 117 applies. If it's going to be section 117 into the community, then I would say at this moment in time, it would be for social care to be seeking the deprivation of liberty if that's needed as a planning mechanism for when they're discharged into the community. But it will depend largely on what that accommodation is going to look like, who's the commissioner, what's been social care's role up to date. When the changes come in post next April with the liberty protection safeguards, it's going to become possible for the health sector to be applying for the safeguards. So there might be a slight change then. But again, you need to look at what that accommodation is in the first place. No, Sharon, I'm not saying it becomes regulated. I'm saying they can apply to the CQC to have it become regulated, either the CQC or Ofsted, depending on the nature of the setting. The involvement of the CCG will give you potentially more options because it may well be that they can commission something which is out with the usual social care estate. And sometimes having them involved is very helpful in cases because they come up with other options. But no, they wouldn't deal with regulations. You would then have to apply to have it regulated by Ofsted or the CQC. All right. Thank you all then. I think that brings us to the end or thereabouts. Just give a couple more minutes, see if there's any other questions that do pop up. You've got my email address. You've also got, I think, the clerk's email address that have arranged all this. So please, if there's anything else that you inevitably think of after the event, just reach out to us. That's fine. And yes, thank you all very much for giving up your time this afternoon. I hope it's been of assistance. To those people that I said I would come back to, I think there was a question about which regulation and a query in terms of the Welsh jurisdiction. So let me look at that. The slides and notes will be sent out to you again with the link to the recording. So I'll include, I think the easiest thing to do is include those amendments into the notes so that you have the specifics when you get them. Thank you all very much then. Goodbye. I'll end it now.